Andy, okay?
Yeah.
I obviously was pleased that the district attorney indicated that he was going to conduct an investigation concerning this. I think that there are two critical things that he said, maybe three. One is that the accuser here knew of the bag, that the bag contained an item of her clothing, and that she apparently had accompanied her mother. So she knew what was in this bag. And I think that's a critical fact that will obviously loom large in his investigation going forward. It seems to me that if someone knows that a particular item is not what it's portrayed to be later on, they introduce that through their attorney into the case, that at that point in time, they're starting to obstruct the investigation. It's obvious that the intent here was to undermine the science, undermine the DNA results, which were clearly favorable to my client, inconsistent with the accusations that were being made. And so I think it's a critical fact that Mr. Sedita shared with us today, that this girl knew that an item of her clothing is actually what was in this bag. And then later on, at least at this point in time, we see no efforts to stop, if you will, this hoax from going forward, knowing what that bag originally contained. So I think that's a very critical fact that will weigh heavily in his determination of the significance of everything that he's learned. I had no doubt that the integrity of the evidence was going to be intact. I had confidence that the people had collected it properly and tested it properly, and they proved that today in spades. I said from the beginning it was a hoax. It's obvious what the intent was. To me, at minimum, there's an attempt here to obstruct governmental administration, at minimum. And an attempt is a crime in New York, just as much as a completed crime is. And so having knowledge of what the bag originally contained, having knowledge of the bag being perpetrated as something else, and then allowing that to go forward, taking no steps to stop it, with the intent that it undermine the science in this case, I think is a very serious set of facts, and I'm confident that Mr. Sedita's office will sort them out correctly.
Did you know, and you had said, if you used terms prior to this hoax or red herring, or
I use both terms.
Certainly question the credibility of what was being stated earlier in this. And I was wondering, did you know as well that Mr. Sedita said the thing is rape kits are never placed in bags, boxes, not bags. Did you know that?
Well, I'll tell you what I knew. I knew that in every case that I'd been involved in, boxes were used as opposed to bags, but not only that the bags did not contain, the evidence bags did not contain the actual name of someone who was complaining, as opposed to a reference number, a case number, and so on. And here, Barry and Herb and so on, who were in the office here, my partners, when we first saw the press conference and the bag was put on the table and the name was there and so on, we're like, this just doesn't happen. So that was the beginning of it. We do know that people are given bags at the hospital, sometimes to transport clothing and so on, and we suspected that that's what this was. But today, when Mr. Sedita said that the actual accuser was present when this bag contained her clothing, to me demonstrates knowledge of what the bag actually contained. And to let that go forward to try to perpetrate a hoax, I obviously think is a very, very critical fact that will be weighed.
Have you advised your client of this latest development?
No, actually, this We just listened to the press conference from Mr. Sedita, and I haven't had any conversation with him about that. Yeah.
Well, I mean, we've
One
heard
minute.
today, in very bold words, that the accuser's mother perpetrated what has been a bizarre hoax over the past 48 hours. We know from the findings you were presented, admittedly today by the DA, we know what the DNA evidence was about. You hinted at this before. This could end up, what we've seen in the past 48 hours, a cautionary tale, a terrible story for victims who want to come forward. What do you say about that?
Well, you keep saying that, victims who want to come forward. Listen, there are two parties at minimum involved in these cases, and you have to determine in the end, when you know all the facts, who's the victim. It's not unheard of that there are false claims. I mean, that is a fact, and a lot of people have been dealing with this as if that's not a fact, and it is. I've had a number of cases over the years where, for one reason or another, one motive or another, sometimes revenge, sometimes marital situations, sometimes money, claims have been made that are false in criminal cases. So all I'm saying is hold an open mind until all the facts are in, and don't be so quick to label someone as a particular person, as a victim. You don't know until the end who the real victim is.
And what about any kind of civil lawsuit against the complainant in this? What are your thoughts on that?
Well, those things are not, out of the realm of possibility. I mean, this is a very serious thing. Obviously, Mr. Sedita's taken it very seriously and indicated that it could have an impact on his course of action going forward, which is a reasonable position, obviously. And it could very well have an impact on what we do going forward. And rather than speculate, all I'm telling you is it's a very relevant fact. We take it very seriously. I mean, think about this. There was an effort here with an item that the actual accuser knew the character of to, if you will, undermine the science that completely supports my client. That is a very significant thing, and it can't just be ignored. I mean, this sets the system on its head.
One
Does
thing
Mr. Iwano-
one thing that Frank said is that he had no evidence that the complainant in this case knew that the mother had brought the bag home, which is different than knowing that there was evidence put in it at the hospital. So
Yeah, but he said that the accuser knew that this bag had contained an item of her clothing.
But didn't know mom
And
brought it home.
that's what he said today, that it contained an item of her clothing. Now, whether or not going forward, she watched the press conference, she saw what the bag was then being used for, she knew or should have known it was the same bag, allowed it to be perpetrated, allowed the hoax to go forward. Those are all things that Sedita will sort out. We have no access to her, so we can't ask her the questions.
Frank
Does
said
Mr.
earlier
Iwano
today-
need to be-
Frank said earlier today that really it went as far as to grab a copy of the New York State Penal Code and said, there's really nothing, at least on face value, that I can see that violates any statute in New York State Penal Code. However, he said he's going to continue to investigate it, but you seem a little bit more confident in that an actual law was broken. Why is that? Could you explain it?
Well, he said that he's continuing to look, and I believe he will be. To me, there is a statute dealing with obstruction of governmental administration, and it takes into consideration not only a completed act, but an attempted act. Here we have somebody with knowledge who went forward, who gave something to a person who logically you could feel and believe would take it to the authorities or use it in some way to obstruct or undermine the science. To me, that starts to sew together all the elements necessary to demonstrate, at minimum, obstruction of governmental administration. I mean, why else would you do this if you weren't trying to undermine something you weren't happy with? And by giving it to your lawyer who you knew was part of the system, who you knew was part of the legal process, if you will, what other conclusion could you come to except you thought that lawyer was going to take it forward and use it to obstruct something?
Frank said.
This circus was perpetrated with or without knowledge, and the only reason it truly became a circus for 48 hours is because a lawyer did this. Should that lawyer be penalized, sanctioned? Is he shamed enough? What do you think about that?
Well, I think that he has explained that in good faith, he accepted what someone told him. This wouldn't be the first time that clients got together and tried to influence the system, influence the legal process. And I think what he said is that he took their word for it at a point in time where it was clear to him that their word wasn't reliable. He then came forward and said, I have an ethical obligation to divorce myself from this case, and from not only the family but the accuser herself. So I mean, those appear to be the facts. I've seen lawyers in the past be duped by their clients, and the ones who, when they figure it out, come forward and do something about it are the ones who are acting properly.
Well, you called it on Wednesday grandstanding. Do you think that it was too brash a move to bring out the evidence?
Well, you know what? I wouldn't have handled it that way. To me, if I sincerely thought that I had a piece of evidence that was discarded or not part of this of the stream, I would have gone to the authorities and would have said, here's what I have, and here's what I think the significance is, and you should do something about it. That would be my style. Everybody has their own style.
Will you seek sanctions against Tom, or is he going to let it go?
Not at all. It's not my position to be involved in anything like that. As far as I'm concerned, this is turning out the way it should. It's painful. It's terrible that my client has to go through this. I mean, look at what's happening here. Every single day, I have to look at 15 of you. Not that I don't like you, but I mean, my client's the one who's suffering for this.
Frank said this is not a question of whether this will go to a grand jury, but if it will go to a grand jury.
That's his prerogative, and he has to analyze, as he said, what impact this has on the case, added to the results he already has of the DNA. He has to add all those things together and decide what to do. No one wants to go forward with a case they think that isn't there, or isn't credible, or is of questionable credibility, or that they may lose on both sides. None of us want to do that.
Paul Rob Belgies with ABC Chicago. Apologies if you answered this already. Two questions. Now that Tom has stepped away from this, have the two of you, because I know your acquaintances, spoken? And then my second question, have you spoken to Patrick about what has transpired? And if you, I know you can't go into details, but if you could just outline that conversation.
Well, we just had the press conference and of Mr. Sedita, and then you all showed up, so I haven't talked to Patrick yet. I will, obviously, after this is over. As far as Iwano's concerned, Iwano and I haven't had any substantive conversations at all. So that's the answer to that.
The district attorney really hammered the if when the question came up about the grand jury, and that is the first time we're hearing it publicly, presumably the first time you've heard it. When he said if, what ran through your head?
I think it's logical to have those things running through your head if you're trying to evaluate the case and look at the science. I mean, the DNA results are huge, at least in my opinion. And obviously, I'm sure that that's going to impact on the ultimate decision. And now you have this. I mean, now you have a concentrated effort to remove from a case something that is completely consistent with my client's position and inconsistent with the accusations. And you have an elaborate attempt at a hoax to remove that from the case. I mean, that speaks volumes about how important that DNA evidence is. or the lack of it, is in this case.
Just going to the defamation lawsuit, Billy mentioned something about that last night. Is a defamation lawsuit possible?
I never said a thing about that last night. I was asked whether or not there was anything that we were contemplating as far as our own lawsuit, and I said all those things are on the table, and they are on the table.
There was rumor that it was a $3 million settlement before the DNA, and that was dropped after the DNA. You wanna
I'm
comment?
sorry, there's a what?
There was a rumor about a $3 million settlement before the DNA was released. Do you want to squash that now?
There have been no discussions about settlement. I have not discussed with, today you notice that they identified 2 lawyers who the accuser has. One was Mr. Iwanu, and the other was identified as a civil plaintiff's lawyer, and that is a person who shares offices, I guess, with Mr. Iwanu, and that's Mr. Ciccone. He has been in the case since the beginning, and so has Mr. Iwanu. I have not had conversations with either of those 2 about settling this case. Ciccone is a plaintiff's lawyer, as was indicated to you today. Plaintiffs, lawyers, sue people. I have not talked to him about this case.
Do you believe the complainant had to be involved in the hoax perpetrated by her mother?
Well, here's what all I can do is rely on what was said today, and the facts that were laid out by Mr. Sedita had her in a position to have actual knowledge of what this bag actually contained as it was delivered to the family.
The net benefit of this 48-hour circus is, how do you qualify it? I mean, we've got an if, we've got an exoneration, we've got everything on the record. It was a circus. It surely has been hell. The net outcome is what to you?
Well, first of all, I think it underscores what I've said from the beginning. Don't jump to conclusions. Don't be surprised by anything in the legal system. And this is clearly demonstrating that you should keep an open mind and wait till all the facts are in.
So what?
And just any steps, lengths, efforts are possible in legal cases. I mean, we see it all the time.
Can you outline in any specifics what did happen the night of August, or the morning of August 2nd?
I indicated a long time ago that the last thing that I would do is to discuss anybody's accusations or the responses to those and so on. Frankly, ethically, we're not permitted to do that. I am permitted to respond to the statements that have been made, and I have been responding. And today we're responding to not only Iwanu's last night, but we're commenting on Mr. Sedita's conference as well.
In case it gets, turns into such a...
I'm sorry, what's your name?
Mark.
Okay.
Have you ever
Would-
seen a case around here that turned into such a circus in
I'm
such
sorry?
a short amount of time?
I can't hear you.
Have you ever, do you remember a case around here ever getting this mucked up and turning into a circus in such a short amount of time?
I don't know about a short amount of time, but we have had some pretty bizarre cases over the years where people fabricated things. They tried to change evidence. I mean, we've had, this isn't the first time that somebody has tried to perpetrate a hoax on the legal system. We see it every day. You just see the cases that get attention. In fact, we have a phrase sometimes when we go into court and various people are testifying. We call it test of lying because we see it so often in criminal cases. So we're not surprised by anything.
You said there were 2 counselors for the alleged accuser. You said you've engaged no one in settlement talks.
I haven't had anybody do it either.
Has anyone reached out to you from the accuser's side? Do you believe this is a money grab?
Whether or not someone has attempted to reach out to me, I'm not going to comment on today. But I can tell you that I've negotiated with no one. I haven't reached out to anyone. and I don't intend to.
Is this a waiting game now? Pretty interesting last couple of days.
Well,
know
I
it's
think,
tough to predict,
yeah,
but-
well, clearly, we're gonna have to wait and see what the next step is, from the prosecution standpoint, sure. And where the investigation goes about the people who were part of this hoax, and what's gonna be, the end result.
What would you hope for that? Would you hope that some measure of law is taken care of for them?
I think anybody with the stakes this high, think about this for a second. My client's career, my client's reputation, my client's liberty, all of those are involved here to the highest level. Anybody who tries to corrupt the process and to take any one or all of those things away from him should be punished. There is no room in the system for this kind of hoax. It corrupts it to the core.
Financially, he's lost some endorsements and other things like that. Can you speak on any of that? Do you have any knowledge of endorsements that he's lost?
Only what the public knows. I'm not his representative, and I haven't, been involved in anything like that. But I've read the same stories you have, and clearly there's not only that, but people say things, they make assumptions, and they say negative things, and so on. And here is a great young man and a world-class athlete, perhaps the greatest athlete to ever come out of our city. And look where we are, and look what's happening. And it's just, anything like this where you try to corrupt the system just can't be tolerated.
You had some pretty positive words when you said, what you would say to Patrick Kane on Wednesday. What would you say to him today?
Well, our clients, this is very tough. Anybody who's under, scrutiny is under a lot of pressure. And so we, continue to support them and to tell them to have faith in the system. I have faith in the system. I know the system has flaws. I've seen them over the years. And we just try to encourage our clients to have faith in the system. And we do our best to make the system work.
Is the fact that all the chain of evidence stuff has been resolved, do you think that's brought people's confidence back into the system?
Well, I don't think there's going to be any question about the results here of the DNA, and that's the only thing that we've actually been focusing on so far.
If he should be charged, could he get a fair trial here?
What's that again?
If he should be charged, if it came to him being charged, do you think he'd even get a fair trial around here with all this?
Well, that remains to be seen. We're a long way away from any kind of commentary on that. We'll see.
Of the 30-minute press conference today, what was the most important fact you heard?
That the actual accuser knew what that bag contained. That was a very, very, very important fact. If you know what it contains, and then you witness someone claiming it contains something else, and you know it's introduced into the legal process and what the consequences can be, and you're okay with that, you're okay with a fraud being perpetrated, I think that's a very significant fact.
Frank said that he didn't interview the accuser. Does that bear any?
Well, I think he said that she has an attorney and that they weren't permitting an interview.
And that wouldn't, but if you don't have any concerns about anything because of that.
Well, she could be subpoenaed before the grand jury and then compelled to testify and would have the option of invoking the Fifth Amendment or testifying. That's not my call. That's out of my realm.
Does DNA have to be present to prove sexual assault or rape?
I'm sorry?
Does DNA have to be present to prove sexual assault or rape?
Well, we think so. Our experts think so. But you know what? That's kind of beyond the scope of what we've been talking about here today. But you've seen the impact DNA has on legal cases over the years. They either make them or break them.
You said last night you wanted, ideal situation is a district attorney says, listen, we're not even going to present it. Today, he said if. I mean, how close is this to ideally what you want? And do you believe that?
You know what? I've never had anything but respect for the district attorney's office here. They've treated us fairly over the years. I had no reason to question them. I'm confident they're going to do the right thing, and we'll see how that plays out.
How do you measure if today? Before it's 50-50, now it's at 70-30?
I'm not. You know, the only person who can answer that is Frank. You're going to have to ask him.
Frank said that he expects this whole thing to be resolved.
Oh, before he leaves
Before he
office.
leaves
God,
office.
I hope so. I certainly hope so. Certainly hope so.
Could you look into your crystal ball for a minute? And where do you?
I wish I had one. I wish I had one.
Isn't it right there on the shelf with the 4?
Yeah, I heard about that. That got a lot of play in the national press. I thought that was kind of interesting, actually.
What do you say to the opposing counsel after this? Clearly, if there is any victim, as we've got to put quotes around everything, he may be the most humiliated esquire in the country now. Do you?
Wow, I don't.
What do you reach out to someone who's been manipulated to perpetrate a ruse of this depth?
Tough day at the office. Tough day at the office. You know what? None of us know what he was told and how convincing it was or whatever. We don't know that. We don't know that.
The DA showing the surveillance video and his elaborate presentation. I wasn't expecting that. Was that thorough and convincing in your
Yeah, I mean, we know all about that. When we go to the lab, we know that everybody's being recorded and so on. They've been doing that for years. The only thing that they stopped doing was recording autopsies, which I wish they would do it, because the doctors used to dictate into a microphone, and then if they changed their mind at trial, you could always pull out the tape from when they were actually doing it. So that's gone now, unfortunately.
You mean audio taping or videotaping?
They would audio tape.
Oh, have you seen that surveillance video before?
No.
Wouldn't Tom know then that it was boxed, a sealed box, and not?
You know what? You have to. I don't know what. Tom wasn't a prosecutor. Tom worked in the DA's office. He was an assistant DA for many years. So I don't know. I told you, the three of us, when we looked at when we watched the press conference, and as soon as I saw the bag and there was a name on it, I'm like, no way.
The DA said today that the clear evidence bag that housed the, now we know, hospital bag came from Iwanu's office.
Yeah. I don't know what they did, how they did it, what was going on. I told you what I fixed on today was that the accuser herself knew what was in the bag originally. And this went forward. And you can assume reasonably that she knew it went forward. She watched the press conference and so on and so forth. So that to me is a critical fact that needs to be weighed in this case.
Would you like this to go to the Supreme Court, sir?
I'm sorry?
Would you like this to go to the Supreme Court?
No,
argue this one?
no, not at all. I would like this not to go even across the street. Not at all.
Should we expect to see you in another 12 hours with the next?
I hope not. I hope I'm doing fundraisers all week for Children's Hospital and taking my 6 daughters someplace, so, and getting beat up by my wife. Don't put that on. Too late.
That
Went
was
to
live.
Chicago live,
That
right?
was live.
That's all I need.
Thank you.
Okay,
All right,
thank you.
She's not in Chicago, is she?
Thank you, Counselor.
He's in Chicago spending your money, right?
Fun day, huh? Well, you have to admit there's nothing boring about this case. What's your name again?
Bud.
How are you, buddy? I'm sorry?
One who's more of a barrister than an esquire, isn't he? Don't you think?
You know what? Tom really is a good lawyer.
Well, of course
He's a good lawyer, good trial lawyer. I can't believe he got sucked into this, to be honest with you. I'm shocked. Yeah, Arnold and I are the same height.
Yeah, I like that. That's incredible.
I'll tell you what he said when he saw that picture.
No. How you doing?
Our actual height is in that other
How you doing?
picture over there.
Great.